So today it is our last class dealing with criminal justice, and as I mentioned, I hope to do a little bit of a review at the end of the class as well. So far with this criminal justice issue, we've seen the connections to child welfare and violence against Aboriginal women, both in losing their status and in not having a proper access to property on reserve. And so it's important to keep in mind that these issues are very much structured by, residential school, child welfare, loss of status, loss of property issue. They're also structured by Section 88 of the Indian Act. The fact that you remember is that Indigenous peoples on reserve have very little control over most of the affairs that directly impact their life, because of provincial laws of general application being what is taken up and applied to them, and Indigenous peoples cannot usually influence that law either federally, because the federal government doesn't seem likely anytime soon to be inclined to repeal Section 88 of the Indian Act, and then secondly, the provinces can't actually single out Indians in passing their legislation and think about how that legislation might apply in reserves, because if they intend to do that, it's suddenly ultra vires. This is then also connected to denial of treaty rights and loss of rights in relationship to economic pursuits and loss of title. So when we come to criminal justice, there's a lot of conditioning factors, as the Supreme Court itself recognizes in the cases that we're going to talk about today in Gladue and Ipeelee. Both of these cases help us understand the importance of this wider context in order to make criminal justice determinations regarding Indigenous peoples who come before the system. So I want to talk about the sentencing reforms of Section 718 2E of the Criminal Code, in particular the Gladue and Ipeelee case, which I mentioned just a moment ago, and we'll see how the court underlines the fact of the need to take this broader context of dispossession into account in making sentencing decisions. Then I want to look at Indigenous institutions of law in Canada. We talked a little bit about this last class. We're going to just talk very little bit about it again. The Aboriginal Legal Services of Toronto and the First Nations Court as examples of kinds of things that are being done to have more participation and more law, more judgment occur through Indigenous principles and standards. And then in closing, to look at Indigenous justice in the United States through the tribal court experience. There was a reading in your materials from the Ottawa court, and there's also a short excerpt from the Navajo court, just to give you a sense of what might be possible one day in the Canadian context as Indigenous peoples themselves pick up law as a tool to address these issues that we're discussing. So that's the outline of our class today. So first of all, we have this Gladue case, which took place in Nanaimo. There were these, it seems like two prairie people were living in Nanaimo. Gladue and Beaver are Cree names. They were engaged to be married. And they had one child at this point, and they had another child that was on the way. There was heavy drinking involved one night at a friend's place, and there was allegations of the woman towards the man that he was having sexual relations outside of their own relationship, to be engaged, but the allegation is that he's cheating on her. In fact, the allegation is that he is cheating on her with her sister. And so pretty serious set of allegations in the context of this heightened emotion with drinking involved. And after observing her partner and her sister come down the stairs, obviously it seemed like they were together. The woman in the relationship confronts her fiance and says, "What are you doing?" and tries to hold him to account of this seemingly extra relational affair. And he denies, but then he actually admits and gives very harsh words towards her. And she's really upset. And so she runs, grabs the knife, stabs him in the heart, and there's a witness. about this altercation that takes place in a townhouse hallway, and she dies, or sorry, he dies. He dies in her stabbing him. And she is charged with second-degree murder. Now, there is evidence of prior physical abuse by the man in this relationship, and I think he had been charged, convicted as well of assault, and served a 15-day sentence about a year and a half before this altercation took place. And so there was some question as to whether or not her actions and reactions toward him were going to be subject to what's sometimes called in the case law the battered or fearful wife syndrome. But even though this evidence of prior abuse was there, the court said this was not particularly relevant in these circumstances. So the court didn't go down the path of examining the case in relationship to that fact. So she was then sentenced to 3 years of imprisonment for the murder of her fiance. She's obviously distraught by this. She names the child that was on the way after the father, after the person that she's murdered. It's just a tragic situation all around. She's there in prison for 3 years in the terms of the charge. And the question is, what is the proper interpretation and application of Section 718.2 of the Criminal Code? In deciding what her fate should be, given that she's been convicted of second-degree murder, what should the sentence be? Section 718.2 of the Criminal Code says this, E, a court that imposes a sentence shall take into consideration the following principles, all available sanctions other than imprisonment that are reasonable in the circumstances should be considered for all offenders. Also, all other sanctions other than imprisonment, reasonable in the circumstances, should be considered for all offenders with particular attention to the circumstances of Aboriginal offenders. And that's the question here. When she was sentenced to this 3 years imprisonment, did the trial court follow the injunction of Parliament and pay particular attention to her circumstances as an Aboriginal person who was offending the law here? And the court in the Gladue case is going to lay out how this provision should be construed, how it should be applied. The court found that the trial judge made an error in relationship to the sentencing principles that were applied, and the trial judge did not give sufficient weight to the context of her particular circumstances that are then fit to her in terms of the Aboriginal context of this case. Yet, the 3-year prison sentence is still not unreasonable, given that this was a near murder. We've got manslaughter in place. So 3 years is appropriate here, but the trial judge didn't do their job properly in the way they calibrated that 3 years. So it's not just that you're looking to the outcome in the sentencing context, but it's the justification for that outcome, which again has to pay attention to the particular circumstances of Aboriginal peoples. And what are those? So what are the purposes of Section 718.2e of the Criminal Code? The court addresses these purposes. First of all, they say this is to ensure that every person that is convicted receives a fit sentence, meaning that it's always the case that general principles of sentencing law have to be applied to a particular offender. This is the idea of fit. It's not just that you think about individuals detached from context, nor do you just think about universals and approach the law in that way. The universal sentencing principles have to interact with a particular person before the court. And the court says another purpose here is to ensure that there's a remedial and a restorative aspect to sentencing, which involves some form of restitution and reintegration into the community. And you remember from the Moses case that we studied last class, the issue of restitution and reintegration is not often done well in Canadian criminal law. In fact, when Philip Moses would go to jail, he'd emerge from jail more angry, less skilled, less capable of dealing with the challenges of life. He would have learned other patterns of criminality in that system, and so therefore comes out of jail as a better criminal, not rehabilitated and ready to be reintegrated into society. In fact, he poses a greater threat to the community by going to jail. Even though he's removed from the community for a time, and therefore the community is safe for the time that he's removed, when he comes back, like that Wendigo or the bear walker in the way that doesn't act well, right, there's a further burden that's placed on the community. And these burdens often fall more heavily on Aboriginal peoples, because in Saskatchewan, 80% of the population coming out of provincial prison is Aboriginal. Where do those people go? They often go back to the reserves, or they go back to the urban settings of Saskatchewan, which are heavily Aboriginal. And that kind of perpetration of what's learned in that case, if they don't receive reintegration, restorative, remedial help, perpetuates a cycle of violence, and people end up in worse situations, not only the individual but the community that's attempting to be protected. And so these principles of the criminal code are meant to apply to the individual, yes, to ensure that you get a fit sentence, but also ensure that there's a remedial component, not just for the individual, but for the community as a whole. The court says there's a political purpose behind this, which is to reduce over-incarceration of Indigenous peoples that has a devastating impact on these communities. And they give the statistics from the 1980s up until this case was decided in 1999. And they make the point that the situation is getting worse, not better. That's been the refrain for 40 years. Getting worse, not better. It was the case in 1999. And this is a result, this widespread over-incarceration of bias, which is widespread in the circumstances. So what the purpose is to reduce over-incarceration, get those numbers down. The purpose is also to address the widespread bias, discrimination, racism. Williams talks about racism, and the quotes Williams here. Gladue principles exist to deal with racism in the criminal justice system. They're there also to deal with the crisis in the criminal justice system. Reading from paragraph 64, these findings, that is, of over-incarceration, widespread bias, cry out for recognition of the magnitude and the gravity of the problem, and for responses to alleviate it. These figures are stark and reflect what may be fairly termed a crisis in the Canadian criminal justice system. Interesting choice of words here. As I read these cases again today, I reflected back, because we're thinking about end of term here. Is it the case that this crisis is just limited to the criminal justice context because we have a numerical measurement of overrepresentation? Or might it be that we also have a crisis more generally in our Canadian legal system in dealing with Aboriginal peoples, as you think back to how governance is treated, how title is dealt with. The first claim of Aboriginal title was only accepted a year ago. And we have this hundreds of years history. Or in the treaty context, or federalism, what Section 88 does, or what we saw with Métis people and Inuit people. Can we generalize here and say this crisis does not just exist with regard to criminal justice, but also is a part of the entire crisis that our system is in holistically? It might not look like you're in a crisis in our system when you study business associations, maybe it does, maybe it doesn't. Professional responsibility, intellectual property, bankruptcy, right? Lots of parts of the system perhaps seemingly run well, perhaps, and I know there's critiques in all of those classes as well. But here, the system is built upon a prior system that's been dispossessed. Is our system built on a rock, or is it built on sand if these foundational issues, Canadian law springs from, business association springs from these prior constitutional relationships, intellectual property springs from, bankruptcy springs from the attempt to create the reconciliation that the court's trying to usher us towards. But if we haven't got that right, what are the potentialities of business associations, intellectual property, bankruptcy, family law? I think they are actually significant. This is my opinion, that the crisis we see here is also a crisis more generally. I've talked to leaders of business in British Columbia, and I'm just not adding puffery here. It's to make the point that they regard capital as fleeing this province. People are not investing here. They're taking their money elsewhere where it's likely that they're going to get a better rate of return on their investment because they have certainty in relationship to the property, contract, business relations regime. Because of what's happened here with title not being settled, treaties being very halting, the opposition that many First Nations and Métis people have to development without their involvement. It's not that Aboriginal peoples are opposed to development. They want jobs too. They want to be a part of things. They want sustainable development by and large, but they are opposed to development that doesn't involve them. And if capital can't be productive in this jurisdiction because of the crisis we're under, then this affects other areas of the law. Now, this is a very silent crisis, I think, because capital just moves. It doesn't have to make a declaration as to why they're doing what they're doing. You don't have the kinds of figures that are present here, but nevertheless, there's something wrong. There's something rotten at the heart of our system that we're trying to build all other relationships from, and therefore it needs attention from other areas. So how does the judge apply Section 718(2)(e) remedially? By paying attention both to the context of what we've just described, this greater sense of loss of autonomy by Aboriginal peoples. We pay attention to that context in regard to also understanding the particular circumstances of that offender. And it's incumbent upon the judge to consider both the particular offender and the wider context. Court also says, therefore, in dealing with this crisis, that we have to pay attention to Aboriginal principles of sentencing. This brings us back to one of the overriding, underlying themes of the course, which should be coloring all this here, which is a review of the course, that this area of law is sui generis. Remember, a morally and politically defensible conception of Aboriginal rights will incorporate both perspectives, meaning both the Aboriginal perspective and the wider Canadian perspective. We made that point time and time again. And here, you see this creeping in to the criminal justice context as well. In order to have appropriate sentencing, we can't just be looking to what Western theory around criminology would put into place in relationship to protecting the public and dealing with the particular offenders. The court says we have to look at principles of harmony, restoration. The traditional sentencing ideals are often far removed from Aboriginal understandings of sentencing. We need to look at their customs, meaning Aboriginal, paragraph 73, their customs and traditions, their concepts of sentencing, which vary widely. Right? It can't be a pan-Aboriginal. What do the Salish people say about restoration, retribution, separation? And they will say something about all of those things. Not everyone wants just restoration, harmony. There's reasons for separation, but the Cree might have a different approach than the Haida, than the Salish, than the Ojibwe, than the Mi'kmaq. And the court says these will vary. A common underlying principle is that it has to be a community-based sanction. The court is imploring the criminal justice system to respond here, to pay attention to Aboriginal conceptions on the meaning of dealing with order and peace in a criminal justice context. Now, it is true that this is putting it towards the criminal justice system, not a separate system of justice. But nevertheless, there is that imploring. Barbara?
I just want to make a comment. My youngest brother was killed by a drunk driver, and over the years, and this happened in '72, the young boy who was driving the car, he spent his life helping my father until the young boy died. And that's how he made things right for my father.
Thank you for sharing that. What a great example here. Very personal, tragic situation. Family member dies, but the person that caused that hurt, that harm to the family, spends the rest of their life trying to help that family to make good that loss that was overcome. Thank you for sharing that. These are the kinds of principles that could be activated, and they are hard. You know, you can hear the depth of that in the emotion, but there's something that are nevertheless possible. Right? You have examples of this going on, and have had examples of this going on through the years, through the decades, through millennia in this country. And they're to be applied holistically. The court says we need to alter our method of analysis in dealing with criminal justice matters for Aboriginal peoples, for all peoples, in fact. 7:18 says for all peoples, but in particular, we have to pay regard to the circumstances of Aboriginal offenders, because there are unique circumstances that they encounter. The court underlines this by calling it, again, a duty on the judges. There's a judicial duty imposed. This is not, what's the opposite of mandatory? Voluntary? Discretionary. This is not discretionary. This is not voluntary on the part of counsel, on the part of courts and judges. This is mandatory. They have to apply these kinds of analysis. And they do so by judicial notice. Judicial notice about what? Well, you saw in the Williams case, racism. Court doesn't have to have that proved to them every time if there's circumstances that's in their view as to that being present in the community that they're part of. Paragraph 83, judicial notice of the systemic and background factors and the approach to sentencing which is relevant to Aboriginal offenders. Judicial notice of Indigenous legal traditions. Right? We're saying here, an approach to sentencing which is relevant to Aboriginal offenders. That relevancy comes out of paying attention to these Aboriginal principles of sentencing that the court introduced in paragraphs 70 to 74. And again, it's always important to say, and Aboriginal peoples, as much as courts want to enforce this, that you can't deal with the collective abstractly. You've got an individual before you. You have to make that sentence fit in the context of that individual. So you can't deal with the collective abstractly, but neither can you deal with that individual decontextualized from that collective context as well. It's not like what comes first, the individual or the collective. That's a false game. That's, you know, that kind of John Locke state of nature, the individual came before the collective. Where is that state of nature? It's not present in the Canadian context. The collective and the individual live in the context of one another, and they both have to be put together in working towards a fit sentence. So then there's some questions. Should Aboriginal peoples be singled out by the criminal justice system in the way that this court permits? Does a person need strong connections to the Aboriginal community to apply the Gladue principles? Does imprisonment reduce crime? And should Gladue apply to serious offenses? Now, there's some answers to some of these questions I want to get you involved with in a second. This first one, I'm going to show you a clip in a moment here. But does a person need a strong connection to the Aboriginal community to apply Gladue principles? The court says no in the Ipeelee case, which follows. In fact, the court says, because Indigenous peoples have often been so disconnected because of loss of title, failure to abide by treaties, residential school, child welfare processes, etc., because of the history of colonialism, it might be that that Aboriginal person is disconnected from their community, and it's the very disconnection which requires the need for a Gladue response, not the fact that this person walks around with a headdress and a loincloth. It looks like an Aboriginal, that therefore you would apply these principles. Does imprisonment reduce crime? No. 50 years of studies have come to this conclusion. It's empirically verified. It's very complex in terms of then thinking what you do with that answer. But to act as if imprisonment is always the course that would be followed to protect society is to ignore evidence-based studies. Should Gladue apply to serious offenses? This is the Ipeelee case we're going to read in a second as to the court's conclusion that they should. But I want to have us talk for a few minutes about should Aboriginal peoples be singled out by the criminal justice system. And I want to have you respond to this YouTube clip. Because you're going to exit this class after one almost hour, and we'll never be together like this anymore. And you're going to have conversations about what you learned here, and people are going to ask you, why should Aboriginal peoples be treated differently in the way that they interact with the legal system? And what are you going to say to that? How are you going to respond? I'm sure it's fine to have many different responses. Again, there's no party line. It's not like I'm giving you the answer. I'm hopefully helping you have tools to generate your own answers that apply fit, again, to your own context. Not an abstract universal. I tried not to give you those. But I've also tried to hopefully inculcate the idea that it's not just all decontext to give in individual approaches as well. So here's about a minute.
What do you call a law that treats people differently based on their race? a law that tells the courts that when they're sentencing offenders, that they should be treated differently based on their ancestry, based on the color of their skin. That's called racism. And that's what the Supreme Court of Canada has reaffirmed recently in telling courts in Canada to treat Aboriginal offenders differently than non-Aboriginal offenders. Our illustrious judges in Canada's top court have said that if you're an Aboriginal offender, you should be given special treatment, leniency, perhaps no jail time compared to someone who's not an Aboriginal offender because of the circumstances, the historical wrongdoings against Aboriginal people. Well, where did this come from? This is judge-made law. It comes from a law that came in 1996 when former Liberal Justice Minister Alan Rock made a bunch of changes to the criminal code and changed certain provisions in sentencing, among them telling the courts that they should try, when possible, to find non-jail sanctions for offenders, for all offenders. But then they added in this one line. They added in, while giving special attention to Aboriginal offenders. Well, what does that mean? It doesn't really mean anything. It's ambiguous. And it was left to the courts to interpret, and the courts have interpreted it. And they have said that Aboriginal offenders should get special treatment based on their race, based on their ancestry. It's wrong, and it's morally reprehensible, and it's racist. And we have to start petitioning the current federal Justice Minister, Rob Nicholson, to convince him to change the law, to clarify that all Canadians should be treated equally before the law, not based on the color of their skin or their race. For the Winnipeg Sun, I'm Tom Broadbent.
So this could be a discussion that you would have at some point in your life about dealing with this particular issue. And there could be the inclination to just knee-jerk dismiss it offhand, and that's your right to be able to do so. But there's something, I think, underlying this that is serious on the part of those that make this point. And it's not going to be necessarily the case that you can convince everyone that holds these opinions as to why it is that there might be a different approach. But just to go to the question, which is, should Aboriginal peoples be singled out by the criminal justice system? Is this racist to be able to do so? Is this wrong? Is this contrary to equality and fairness and justice to think that a particular group of people would be given different and read in sometimes this is more favorable treatment in the Canadian legal system? Ideas, Joel?
I forget the words that they right now because my brain doesn't work. But you know, they say that it's difference between there we go, substantive equality and formal equality.
Yes.
So I mean, Aboriginal people are singled out by the criminal justice system. We already know that. That is currently the state of affairs.
Okay.
So if you're going to apply these colorblind policies aren't colorblind at all, right?
Okay. So to apply the insights from Section 15 of the Canadian Charter of Rights and Freedoms, that there are formal equalities but also substantive equalities, and sometimes in getting to equality, treating people differently is what is required. Not all the time, but sometimes that's necessary given the pre-existing and other kinds of disadvantage that might be enjoyed. So, you know, if you've got a millionaire and a pauper, you don't make them equal by just giving them $1. Right? There's differences that would need to be required. If I've got a child with special needs, with autism, and another child that can attend law school, I don't treat those children the same in terms of doing to one what I would do to the other. They require different approaches to ensure that there's a fairness in that. So that's one possibility. Other things you might say.
I think that clip shows like an ignorance of any sort of this, like the actual context of, yes, Aboriginal people are singled out by the justice system, particularly in Manitoba, and they're singled out negatively. Mm-hmm. And so this is an attempt at a remedial measure to try and lessen that negative impact.
That's
it's
right.
Not, yeah, like just the context in Manitoba right now,
Good point.
It's still terrible.
So the context also has to be taken into account here in coming to some of these answers, particularly in Manitoba, where you've got 60–70% of people in prison being Aboriginal, and then the context as well of the child welfare, residential school, violence against women, etc.
Yeah, I think Sean's point is, just that it comes from kind of not knowing, understanding context. I think that's why this kind of sentiment really resonates with a lot of people that we saw in the YouTube video. Because if you don't know a lot about history, and I think the way that history is often taught, it's like Canada's this glorious, wonderful, fair country, and it's always been so. And so people think that, and they're like, well, why, yeah, like, it was great, we came here and we helped the Indigenous people, and why should they be treated differently? And I really do think that if you, at least some part of it needs to be educating wider society if you want these kind of things to be more accepted about what's happened and why we're in this kind of problem.
Yeah, that's right. And sometimes, just in drawing further on what you say, there's this other narrative, which is, we came from war-torn Vietnam, World War II, Southeast Asia, and we are now, in this next generation, we made it. Why can't you do that the same? We are from an oppressed background as well. We came here made good. What's your problem, Aboriginal people? Why don't you just get it on? Like the people from, again, World War II or other war-torn places are able to just get on with life. And so there's that narrative that also gets played through. Yes.
So I think context is important, but I think also some people who maybe don't have the capacity or opportunity to think about historical context. Sometimes the conversation can be shifted to more the outcome. So talking about what you mentioned earlier in terms of the evidence that shows how incarceration does not fix the problem, it doesn't reduce crime rates, and how I guess there has to be changes to sentencing so that the overall objective, the outcome in terms of having safer communities, what does that look like?
That's right. And in fact, the court says here, this applies to all people, the idea of having a fit sentence, the idea of taking account of context. It's just that we need to take account of particular context of Aboriginal peoples here.
I would offer that as well. I think there's, that man would answer yes to question 3, and so there's a fear underlying this that by giving out what he's seeing as lenient sentences, you're exposing the community to risk that you've had a criminal maybe doesn't get jailed.
So the fear of my community is not going to be as safe because you've got this person, often Aboriginal, who's been released without proper discipline. And I have to say that there's something powerful to that should be paid attention to. We need to reason by paying attention to our emotions. Right? You just don't go automatic. When you reason, you reason by that connection, but we can't just have our emotions govern us either, right? We have to have emotions and the intellect joined in that way, but we need to deal with the fear.
I think it's quite a broadly construed and relatively sort of static view of the criminal justice system generally, which I think is arguably changing in the sense that if we look at the Aboriginal context and then just look at it more broadly, certain offenses are being responded to differently. You have problem-solving courts that are coming up, not just in the Aboriginal context, but in a lot of different contexts that are looking at rehabilitative options and addressing root causes as opposed to just having a sort of backward application.
So this is an interesting comment. It's about the entire justice system needing a recalibration, not just for Aboriginal peoples, but across the board. And there are some movements that are taking place that are trying to move towards restorative, holistic, not just relying on imprisonment as the sole means of dealing with criminal justice issues.
Kind of along the same line, and what we mentioned a minute ago about how there are these other factors to take into account for all people and their different backgrounds, and that is important in all contexts, not just the Aboriginal context. But what I think maybe
is behind the singling out, as it's being called, is because of the role of Aboriginal or Indigenous law to play in the space, that's why, or could be why that's there, because it's allowing for another legal system to play a role in this process, whereas that doesn't come into
Yes.
play in the other contexts.
That's right. With other contexts, you wouldn't be taking account of the sentencing principles of, I don't know, name a group in the world that's come to Canada, but in the Canadian context you do. The court doesn't connect this to Section 35 when they make the point of the need to pay attention to the customs and traditions of Aboriginal peoples, but they could have. And in fact, I think the judicial point would have been more persuasive had that occurred, to see this itself as a constitutional issue. Right now it's decontextualized from 35 on, but it could actually find its place one day. Possibly it's integral or distinctive culture for people to be able to create order, peace, deal with harm.
I worked a bit in this area over the summer and has some contact with people from Aboriginal Legal Services in Toronto. And one of the points that they made quite strongly is that the due factors and all of this policy being taken into consideration when Indigenous people are before the courts shouldn't be considered as Aboriginal rights, because it's not a right so much as the Canadian justice system trying to fix the mess that it has made
Yes.
of Aboriginal people's lives.
Yeah.
So that we shouldn't be
So there'd be a
conceptualizing it as
reason to
something-
put it aside and separate it from Section 35 in this context, because it's the Canadian system that's fostered in large part this mess, although Aboriginal peoples are not without blame and responsibility. Remember I made that point earlier. But the sense of culpability might not be the same in other community contexts because of what the Canadian state has done to Aboriginal peoples. They might not have done to Vietnamese or singling out, but other populations.
That was essentially my point, but yeah, that these other people who come to Canada, the context isn't exactly the same because Aboriginal people, this is their land, right? And so it's the imposition of colonialism over every aspect of your life in the place that you're from, so that every aspect of your community is affected. I think that can be different than a single, like, traumatic incident like war.
And the court is saying here, pay attention to context. Don't just make us universalize, right? And again, different context, but including the Aboriginal context here. Now I have to say, I'm myself really disturbed about making decisions on the basis of race. I get it a little bit in the Section 15(1) and 2 context in regard to substantive equality. Sometimes you need to take account of race to undo a harm that's been perpetrated on the basis of race. But if Aboriginal peoples who are in the system pick this up as, well, I'm a race, and I get this different treatment because of the race that I'm a part of, or if people look at them as crown, as judges, as, well, this race has this special need that needs to be fixed, I'm all for getting rid of that kind of language as much as possible and jettisoning that. And so I'm with this guy on that point. So what's the justification for singling out if it's not on the basis of race? For me, it's on the basis of these are political communities that have been disrupted, that we're trying to create some sense of restoration as we've looked at other parts of the course. And it, I think, would be better to think about these contexts in that jurisdictional mode where you've got political nations that have peoples that are disenfranchised and not able to fully exercise autonomy. And again, there would be limits on that for me too. It's not like, not about proportionality, but I worry deeply about race as a basis for making decisions. And some of that worry, though not all of it, is attenuated if we switch the lens by which we look at this issue to more of a political ground. So I'd be able to go along with this guy in a little bit of what he's doing, but then my reasonings would go obviously away from where his conclusion ends up. Other witnesses?
I think I share that worry. I'm originally from South Africa, and a lot of my family, not my immediate family, but people that still live there, are incredibly racist. And I think it's antagonized by the strong affirmative action that's there. But I also think, well, what's the alternative? Especially there where it is sort of a very black and white situation more than here, literally.
Yeah.
But yeah, I can see it as promoting this sort of racist attitude. I also think that attitude is fading. Like, that man has very strong racist opinions, but I think that there's less platform for those to be spread these days. I hope. And as an example, like CBC just closed down the comment option on any article about Indigenous issues, and it sort of, I think, shows that maybe as a society we just need to be less tolerant of racist views. I'm not sure if like basing a policy on race is antagonizing that or not, or if it's just that people are racist. I'm not sure.
Okay.
I think my question would be, if you get rid of all these special treatments, how do you balance everything? You know, because our world, and it's very much my world, is very much kept down with the Indian Act and all the laws that flow out of that. We still are trying to grapple with going from probably more than 30,000 people to less than 600, and trying to put our customs, our laws, all those things that people from away come here with their own preconceived ideas, you know, and I get angry because I feel that if this was a just world, my laws, my language, my customs, and yes, I can put on my headdress and things like that now, but there was 100 and something years where we couldn't even look sideways or gather in more than 3 people, you know, and so people like that I've dealt with my whole life, and you know, they look at the color of my skin and make snide comments and things like that, so you know, it really frustrating as a woman, as a First Nations person, and as the head of my family, to see the kinds of things that are allowed to happen under the guise of, oh, it's the law, you know, and so I gladly make things right with him, you know.
So the law is not neutral just because you don't take account of these distinctions, right? The law, in the guise of neutrality, keeps people down. And this class, we've gone in now for like 20 some odd lectures, not, I think, being raging, but trying to be reasoned around this and look at the situation with eyes wide open and see that in many of these turns, when a neutral system purportedly is there, it ends up not recognizing title, treaties, putting kids in residential school, help to child welfare, taking women's property, not allowing them to have status when they get married, not allowing federalism to have any Aboriginal space for governance, preventing Inuit people from living where they choose to live, stopping Métis people from forming societies that have an element of their tradition that they can channel and make decisions in relationship to, right? This is not like, let's just all be equal. It's already the case that there is a heavy hand on that scale of justice that really works to the disadvantage of Aboriginal peoples. And I have to say that, and the court says, widespread bias, racism has led to many of these systemic failures. Sean?
Yeah, I was just going to say that, like, the law is designed with somebody in mind, like, the law isn't neutral, the law is designed for the white heterosexual male, generally, often because those are the people who are designing the laws, and also because historically that's just who's been favored. So those biases are still inherent in everything we do.
Including me, when I come to design a law, write a law review article, consult with the government, talk with the First Nations, we come from a place, the point that we're trying to get at is to question what's deep in me, the way I react to this, so that I don't, again, just do something knee-jerk, right? I've got a considered response, and again, it's so hard to do that across the entire range of life, particularly when emotion is so heavy given the challenges that have been faced. We have those tools, right? There's a message of hope in this class, despite all the garbage that we've seen. I've seen that hope lived out over 20 years, as I've seen what people like you go on to do. And sometimes I'm a little disappointed, but not often. Most of the people do pretty good. There's a couple students that I wish they would have chosen another way of dealing with that. Yeah. But there is the idea here is to think about your role as agents in involving yourself in this way. So thanks for that discussion. We've got these examples that we talked about last class, like Aboriginal Legal Services of Toronto, that try to put into place a system to deal with these problems. It's not a separate system. This is very much just still participating in the mainstream system, but in ways that try to bring forward your creativity, the creativity of Aboriginal peoples that are working in that system. Likewise, with the First Nations Court in British Columbia, you also have those opportunities to be able to find that place. You have the Ipeelee case, just carrying further the Gladue principles. This man Ipeelee and Gladue, two men, were subject to long-term supervision orders under the criminal justice system, and they breached those orders. And the question is whether or not this section 718(2)E of the criminal code applies to the long-term supervision order, because these people are considered to be dangerous offenders. Can Gladue principles apply to someone who's considered to be a dangerous offender? And the court comes to the conclusion, yes, they can. Why? Because the objectives of the long-term supervision order are, yes, of course, protecting the public, but part of protecting the public occurs through rehabilitation. Not just warehousing people. If that person can be rehabilitated, that long-term supervision order, which is there for that rehabilitative purpose, is fulfilled. What is the reason for 718(2)? We already saw that in the Gladue case. But the court has said, here now, remember Gladue is 1999, Ipeelee is 2012. The court said the problem has grown worse in terms of Aboriginal people's crisis with the judicial system, the criminal justice system. And that crisis has grown worse through judicial misunderstanding and misapplication of the Gladue principles, that section of the criminal code. There are criticisms that sentencing is not appropriate to deal with overrepresentation. The court says, of course, this is just a small slice of what needs to be done, sentencing, to deal with the issues of overrepresentation. But as a judiciary, we do have control over that small slice, and we cannot derogate our duties in taking account of that. So we recognize this isn't going to solve everything. It's not a panacea, it's not a utopia, but it will solve some things, maybe even just for people along the way and a few communities along the way. But if we have control over that, we can't abandon the field, the court says. In regard to whether or not this is a race-based discount, the court comes to the conclusion that it should not be a discount. It's always about the fit. And sometimes going through these kinds of processes can be more onerous than going to prison. Like, just let me do my time. I don't have to address my issues. I can just, go reassociate with a kind of lifestyle that I'm familiar with, and out I come again. To do the work of restoration and rehabilitation sometimes might, in the other direction, be considered more unfair, because there's things required of these people that wouldn't be required of someone just heading off to prison. And then as to whether or not it's unfair to make distinctions in sentencing, the court says, of course we make distinctions in sentencing. That's our job. This is a shot across the bow of minimum mandatory sentences that take control out of judges' hands in being able to calibrate a sentence fit to the person that they see in front of them as they apply the law. They're saying we need to make distinctions in order to ensure that we're just. Injustice can arise and be perpetrated if we can't engage in this fitness exercise. Now, I mentioned this before, there's no need for a causal link between Aboriginal circumstances and offenders. You don't have to show you grew up in a community or know your culture in order to potentially have these principles apply. There has been uneven application of this principle for violent offenses, and the court says it's likely going to be the case, but often that's going to be such that violent offenders are going to get higher rates of prison time. We reaffirm that. But don't universalize that. Don't take that as all time and place permission to not create a fit sentence. So here, these applications of the principles were not properly applied. So that's the Ipeelee case. We then have these examples in the United States of the Navajo courts, and I've taught an entire class on tribal courts actually for 5 years in Minnesota. That's what I did. And they have bar admissions courses. Here's an exam. Bylaws for their bar association. They talk about what their common law is. So there's statutes, there's constitutions that can be applied, contracts, due process, domestic, probation, property, just as examples of the types of things that the Navajo bar would be involved in. So there's ways of patrolling the practice of law in this context, which again is very syncretic. These people often go to law school like you do, but then they learn Navajo law as well. And we put it together, as we've tried to do. Morally and politically defensible conception of Aboriginal rights incorporates both legal perspectives. Navajo law incorporates Anglo-American law, but it's not determinative. Navajo law, the fundamental law of the Navajo, is what everything is judged in relationship to. Likewise, we've got another case in the materials here. And this case, the Navajo case, that's in the materials, is just briefly excerpted on page 1134 and 1135. Shows how they dealt with the impeachment of a president of their nation through the application of Navajo. Someone that took bribes and kickbacks, criminal law injustices that raised to the highest kind of a Watergate type problems were dealt with by these people on their own terms and in very positive ways. Likewise, this case, the Ottawa Indians, because I want to get to the review here for a second, I'm not going to go through the case in detail, but a judge of the Little River Band of Indians made a false insurance claim. He said he was on the business of the tribe when he got into an accident. In fact, when he got into an accident, he wasn't on tribal business, but he nevertheless submitted that insurance claim under the tribal insurance. He was caught, attempted fraud. He tried to say, oh, we didn't have an attempted fraud in traditional law. And the court was having none of that. In fact, they said, yes, we do. And they told a Nanabush story. They told a trickster story about fraud. And they used that as the primary principle to be able to hold him guilty as charged and convicted. They also, he said, well, in some of our statutes, we borrowed from Michigan statutes. The tribal council sat there and created our criminal code, but they said if there's any gaps in this criminal code, the laws of Michigan will apply to deal with those gaps. It just so happened that the crime of attempt was in the Michigan criminal code, and he said that's unconstitutional, beyond the jurisdiction of the Ottawa tribe to do that. And the court says, no. Indigenous law is not just what was once upon a time important to us as people. It's the choices that we make today. And if we want to pull in a Michigan statute and make it a part of our legal system, that's Ottawa law at that point. It's not Michigan law anymore. There's a way that. And then finally, the court says, we have this concept in Anishinaabe life called Ohima, which is to be a leader. It's actually to count one's followers. Here, you violated that principle of being that kind of leader, Ohima, because of your acts here. You burned yourself, just like that trickster character, Navajo, burned himself when he attempted to pull a fast one, a trick on others, and suffered the consequences from that. You now have to suffer the consequences from your crime of attempt in these circumstances. These two cases show that life is not rosy and romantic on reserves, right? A tribal president goes off the rails. A tribal court judge goes off the rails. But if you have a process in place which is transparent, has checks and balances, accountable, takes account, deals with the best principles that are present in what you're learning now, but also the best principles that are apparent in their own legal tradition, maybe we'll be here in the Canadian context one day, maybe even a better place than they are, which is, in order to come to a morally and politically defensible conception of Aboriginal rights that incorporates both legal perspectives, we need to see more of these perspectives stand alone on their own terms, be invigorated in their jurisdictions and in their ability to do good work and also make mistakes and have those mistakes corrected within these systems. There is some positive examples that can be learned from this. Again, I'm teaching a course in May on an intensive basis for 1 month where we will focus more heavily on the examples that we can draw from that as the United States legal context. Now, Barbara asked for a moment to be able to speak with you, and I also want to make sure that I can give you a short review here. So.
When I was a little girl or a teenager, my mother told me that you don't ever accept stuff from other people without doing your part of it and paying it back. And John, this was given to me as to honor me for helping people in Alaska. And I'm giving it to John because I think it's really important that you realize that part of First Nations law is to always make it right for people behind you. And that once you know what has gone on, you have a responsibility to try and change things. And I want to thank you so much for helping me in learning more. I am so appreciative.
That's beautiful. Love the story behind that.
It's
too.
actually a little ermine that came from Alaska. And it's even those stories, it was part of holding up people to have them realize how important they are in the education process of ourselves.
And I want you to remember the story that we told at the beginning of the year about the little muskrat and the mole, right? There's something embodied in this that's a case, right? That's a principle that reminds us of the little ones and what can be done to be able to bring up law from the depths or bring it from a place that seemingly is hidden at a certain point. Thank you. That brings us back full circle to the first story that I told in the class. Now I did want to just make sure that we have a minute to review a broad point in relationship to the first half of the course, which is the section 35 context. So imagine that you have a hypothetical fact situation that raises potential issues of title, rights, and treaties. What framework will you bring to that? It's this framework behind you. You first have to determine if there is an Aboriginal right, or a title claim, or a treaty claim, what is necessary for the proof of that claim. And this graph here shows that you have to ask the proof question. And you have different proof questions for rights, for title, and for treaties. Proving Aboriginal rights has to be something that's integral to the distinctive culture of Aboriginal peoples prior to the arrival of Europeans. You have to start the clock running here for proof at contact. We saw in the Vanderpeet case, the Gladstone case, that test developed, and we saw a claim for hunting and fishing rights there. Hunting and fishing rights, sorry. Was it integral to the distinctive culture of the Stolo people to be able to trade fish for food? That's the test for proof there. We also saw that applied in the governance context in the Pamajuan case. And then we have open questions as to whether or not there were Aboriginal rights to education. Was that integral to the distinctive culture? Or child welfare? We have open questions about criminal justice and health. Are those things, at the time of the arrival of Europeans, can evidence be marshaled to show a proof of a title? Now with the Métis people, the calibration of proof is not at the date of contact, but it's between the date of contact and the effective European control of the area. And there are different standards then as to what needs to be shown to prove a Métis right. We don't necessarily try to what's integral to the distinctive Métis culture. They ask questions about the community, and they ask questions about the individual's relationship to the community. That's the Ipeelee case. And so you hopefully will review that. And then in the Inuit context, we haven't had a lot of discussion of Inuit Aboriginal rights, because often things come up in the treaty context. So there's a little bit of an open question as to what the proof would be for Inuit, but the date of contact would be much later in the Western Arctic and in the Eastern Arctic. But the biggest point I want you to get here is that proof of Aboriginal rights is different from the proof of Aboriginal title. First of all, the date for the proof of Aboriginal title is the assertion of sovereignty by the Crown, not the date of contact. And sovereignty can sometimes be asserted hundreds of years after contact. And you need 3 points of proof for Aboriginal title that come out of the Dalgamut case and are found in the Chilcotin case that have to do with a sufficiency of occupation, with a continuity of occupation, and with an exclusivity of occupation. And you'll remember the sufficiency of occupation is a territorially based claim, not a postage stamp idea of sufficiency. So that would be proof of Aboriginal title, a different date and a different set of questions. Proving treaties, you go to the Siwi case, because there are cases that you should be able to marshal under each of these sections, right? Here we've got Calder and Delgamuuk and Chilcotin, and here you've got Sparrow and Gladstone and Vanderpeet, etc., Vermont. In treaty context, we looked at the Siwi case, we looked at the Marshall case. The Siwi case says to prove what the treaty means, you have to get at the understanding of the Indians as well as the Crown, right? Suganeres. In the Marshall case, the court says it's that which best reconciles the intentions of the parties. And in the Siwi case in particular, the court says you have to look at evidence of what was occurring historically just prior to the treaty being signed, what happened contemporaneously at the moment of the treaty being signed, and whether or not there was solemnity, etc. And then once the treaty was implemented, just in that immediate aftermath, what did the people say that they were doing? So there's a kind of just looking just before the treaty, at the time of the treaty, just after the treaty, to get that common intention that best reconciles the parties' ideas. And remember, the canons of construction are very relevant across all of these provisions. These are constitutional, they have to be applied purposively. The sui generis framework is relevant, but here, the court's very clear. Large, liberal, generous interpretation, resolving any ambiguities in favor of Indians, understanding the treaties as the Indians would naturally understand them, etc. This proof, again, I'm going to say it, is different in each of these contexts. And then federalism could interact at different stages here in one way or another. So that's the first question. Got a fact situation, client walks into your office, on the court, writing an exam. You say, okay, here's some issues. What's necessary to prove these issues? And then making a choice. What's the strongest claim here? What's most likely to succeed or fail? Because when you apply law, of course, it's not just throw the kitchen sink out there and expect everything to stick. It's making a judgment. I want to see your judgment as to what you think is going to be the strongest points of proof, where there might be weaker points, where proof might fail. If there's title that's proved, this is up to the Aboriginal peoples to bear the burden of proof. Then the burden of proof shifts to the Crown, and they have to show whether or not the right has been extinguished. And you remember the test for extinguishment is clear and plain intention. Maybe ambiguity as to what a clear and plain intent might be, but we know from Sparrow that regulation alone is not sufficient to extinguish a right. The assertion of Crown rules in relationship to this pre-existing right, if they don't clearly and plainly say, or intend, I guess, not say, intend to take it away, it's still there. But Aboriginal peoples have to survive that step, and then the burden of proof goes to the Aboriginal group, which is to say, well, we've had this right now that we've proved, and you've infringed it. We have to prove it's infringed by showing that you've caused undue hardship by your law, federal or provincial government. You've acted unreasonably here, or you've denied our preferred way of exercising that right. And note, this framework applies across all three. So proof is different, but the framework of extinguishment, infringement, justification, the questions you ask are the same across all three, although the answers could vary. Because just as we talked about in the Gladue case a second ago, you have to pay attention to context. The denial of a preferred means of exercising the right could be different under a treaty than under title, because there's wording in the treaty, or there's an understanding in the treaty about what the right might be framed by, whereas in the Aboriginal context, there might not be that in the same way. So proof is different. You ask different questions. You ask the same questions across extinguishment and infringement, but just because you ask the same question doesn't mean you'll get the same answer, depending on the context that you apply it within. And the final point is then, if the Aboriginal group is able to show that there's infringement, the burden shifts to the Crown to justify that infringement. And they have to show that there's a valid legislative objective. We now know as a result of Gladstone and Delgamuuk that everything's on. The resettlement of foreign populations, hydroelectric development, mining, etc. So where all the action occurs is, has the Crown exercised its honor in the way that it's used that power that's valid? And there's a lot of things. There's actually 25 things that could be part of the honor of the Crown. That's one of the slides in with Crown obligations earlier on in the course. But some of the things that often come up, in addition to compensation, etc., is consultation and accommodation. And again, though the honor of the Crown, the question is the same that you ask across all three, the honor of the Crown, what's required to honor the Crown could be different in a treaty context, a title context, and a rights context. Particularly over here, one of the differences is that there's pre-proof claims. Like, claims can be made and they're not proven in court yet, and the obligations that the Crown has prior to proof are different than the obligations that they have post-proof. That is in place in this regime. Whereas in the treaty context, this is the Mikisew Creek case. Okay? Once you have a treaty, it's assumed that there's a proof of rights there, and there's another set of questions you ask. Well, what would be honorable to make sure that we live in accordance with that treaty context? And of course, one day we're going to have in the Chilcotin context or other contexts post-proof Aboriginal title questions as well. So, I know that's really quick, but hopefully that framework starts to prime the pump for you as you get ready for the final exam, for that first question, to make sure, again, you know that there are different tests for proof. They're the same questions for all three, but they will be applied differently depending on the right at stake. Thank you for a great semester, and I wish you all the best in your exams and papers.